Hi, my name is Stephanie Tabashneck, and I am a forensic psychologist and attorney, and I'm the founding director of the Center for Law, Brain and Behavior NeuroLaw Library. And I'm going to kick this over to Andrew and Javier just to briefly introduce themselves as well.
Hey everyone, great to be with you all again. I am a senior research associate at the Center for Law, Brain and Behavior, and I help support the NeuroLaw Library, which we'll soon be talking about.
Good afternoon, everyone. My name is Javier. I'm happy to be with you as well. I am an addiction researcher, psychology researcher, and attorney interested in the intersections of law and neuroscience.
And Javier is our actual neuroscientist in the room. So any neuroscience specific questions he's going to answer. So I'm really excited to be here with you. We were last year, I think last fall, and we were talking about the launch of the CLBB NeuroLaw Library. Our first module was on adolescent brain development, and we recently launched an additional module on addictions. And the purpose of the CLBB NeuroLaw Library is to leverage neuroscience to contribute to more effective decisions in the legal system. Courts, I think are probably between 20 and 50 years behind the science. And so oftentimes, for example, adolescents who commit serious crimes are seen as sort of bad apples that will be forever career offenders, and people with addictions are seen as having moral failures. Um, I and other people at the Center for Law, Brain and Behavior do a fair amount of expert testimony across the country to speak about the science of adolescent brain development, the science of addiction, but we couldn't be everywhere. And so the co-founder of the Center for Law, Brain and Behavior, Dr. Judy Edersheim, who's an MD, JD, came up with a CLBB NeuroLaw library, and she asked me to create it, which was ended up to being a huge job. So this is an open source library. It's affiliated with Mass General Hospital. And I also work at the Petrie Flom Center, and Javier is there as well at Harvard Law School. So this is a completely free open source library. And I think what we're going to do first is I'm going to kick it over to Andrew to do a demo. Before I do that, I just want to say, last time that I was here, I was really intimidated to be presenting to a bunch of librarians because I had this wonder if, is this truly a library? Would librarians see this as a library? And you all were so kind, and you said, Stephanie, of course this is a library. And that was really meaningful to me. So I want to thank you for that. And I'm going to turn this over to Andrew if he wants to screen share.
So I'll be screen sharing, but people often find it most useful to actually just hop on the site themselves. So I just shared a link in the chat. But you'll soon see this is what the home screen looks like. So when you get on, we have some nice flashy graphics, and hopefully you are quickly directed to the few different modules we have so that if you are interested in one of these particular topics, you'll quickly navigate to that. The idea is that, this is something that an attorney can hop on and very quickly get, the latest science and have it ready to go and be actionable for the case they're working on. Or if you're a provider or a practitioner or an advocate, you can do the same. So I'll show off the juvenile addiction or juvenile emerging adult justice very quickly landing page. Each module has a resource library, which I'll show, educational courses, and specific tools designed for those modules. Addiction, has their own landing page. And as you can see, we have two modules in the works. We're about to be launching one on trauma, one on memory, which we'll talk about shortly, and then one on aging and cognitive decline and how that relates to financial protection and vulnerabilities. So I'll show you the resource library, which is really the main thing we want to be showing off today. This is a constantly updating open access library where you can, let's say you want to find cases related to addiction, you can click Addiction in the Law, select articles, and find all of these up-to-date recent open access articles. And I think what's really special about the library is some of the features that we've designed with collaboration with a group called Monogram, and they've helped us design this AI using or AI empowered comprehension slider where you can take kind of complicated article like this, often from very complex journals and disciplines, and scroll down to a fifth grade reading level. And we initially had this as an important aspect of accessibility, making sure that people, affected by the criminal legal system, for instance, who may have had fewer economic and educational opportunities, could still be engaging with the science. But what we find and often say is that even attorneys and even scientists with PhDs in the subject find it very useful to be able to quickly use this. And so it's a feature we find useful, and we make sure to fact check or have experts look over the AI adjusted versions to make sure it's still capturing the right ideas. And I'll quickly just show we also have these videos. So with each module, we try to have 10 to 12 short expert-led videos on the relevant topic.
And Andrew, can you also talk about the toolkits?
Yeah, happy to talk about the toolkit. So we also have thought about different ways to make this information just actionable, usable, and we find some people might find it overwhelming to have all these articles. That's kind of the give and take when you want a lot of information available. You don't want it to be overwhelming, and so the toolkits try to make the information that's already throughout the library in a more actionable or tangible way. So for instance, we have one specifically on how to use or leverage neuroscience to promote access to medications for opioid use disorder in prisons and jails. It's far too often just not available to people who desperately need it and would highly benefit from it in prisons and jails. And we found that there are cases in which, showing the relevant science to a court, showing that it's both medically necessary but also effective, is important in granting access, which is an enshrined right according to many court rulings, but often not actually actualized. So toolkit looks like this, where you have some kind of, once it loads, some text kind of outlining it so that you actually have a framing for the issue you're going to be working on. And then what we do is we compile the cases here that are relevant to understanding the issue with short descriptions, and we have the relevant scientific articles with pull-out quotes. And what's pretty terrific is we have it integrated with the library where if you click on it, it'll actually take you to it in the library, and then you can take advantage of the comprehension slider and get a deeper dive into the article. So this is just one way we're thinking through how we can ensure that people actually utilize it, utilize the resources in here that we've spent so long curating, but we'll also talk about a few other ways we've been thinking about making this as actionable as possible very shortly in the presentation.
Thank you, Andrew. And I just want to note that we also have free expert affidavits on the science of late adolescence and on addictions. This is because in many states, it can be really difficult for people who are incarcerated or facing long sentences to get court funds for an expert affidavit. An expert affidavit could be anywhere from $1,500 to $10,000, depending on the jurisdiction. And so we were able to get a number of psychologists to just donate their affidavits, which was, I think, really exciting. Okay, so I'm going to continue. And what we're going to do is we're going to switch it a little bit. And I'm going to do a quick boot camp on the science of trauma and the science of memory. And the reason that we're doing this is because our next two modules are going to be on trauma and memory. And these are really important, especially in criminal court. But I'd also say that the science of memory is important in any court. And we can think about, for example, the hearsay exceptions, such as an excited utterance, and how maybe those diverge from neuroscience. So the library is really a distillation of complex neuroscience research. And so this research is sort of, it's kind of what you will find in the library, but in a very distilled way. So for the vast majority of my clients, and most of my clients are adolescents, late adolescents, young adults who are facing potential life sentences. So for example, I just took a case involving someone who was 21 who's facing a mandatory minimum of 25 years for drug crimes. So he didn't do anything violent, but he was dealing drugs. And so people are facing really long sentences. And then I also have a lot of clients who have committed homicide and other serious crimes. So almost all of my clients have experienced horrific childhood trauma. And we can think about trauma as affecting the brain, but also affecting behavior. And what I really think about is how when people are engaging in ways that to us seem antisocial, at some point that behavior served them. Okay. So for example, when I have a 17-year-old before me and I'm trying to understand, why they, punch someone else on the face, oftentimes it's because growing up, if they weren't the first one to throw a punch or didn't really escalate, very high, then they would be a victim or people would target them. I think it's another reason why people in certain communities, carry guns because, when someone sees the gun, they're less likely to, attack them, so they feel safer. Now, this isn't, an excuse for, carrying weapons or anything like that, but it is, I think, a gateway for understanding. So, adverse childhood experiences are, 10 categories. This research was based out of Kaiser Permanente, uh, now at this point, several decades ago. And what they found is that when they looked at 10 categories of childhood adversity, the more categories of childhood adversity one had, the more likely they were to have all sorts of really negative sequelae, such as depression, anxiety, suicidality, even early death, pulmonary lung disease, a ton of different health effects. And so this not only affects, the brain and behavior, but it affects, the body. Not that we can totally separate the brain and the body. I won't make that mistake. So these are the 10 categories of childhood adversity. I think, there's some debate about whether these should be the 10 categories, and I think we're evolving there. But it just, they're good as a sort of baseline for research. And we know that over 64% of US adults have at least one adverse childhood experience or ACE. And it's not uncommon for my clients to have 7, 8, 9, or all 10. And we know that ACEs are not evenly distributed. So if you are a person of color, you're much more likely to have had adverse childhood experiences or a large number of adverse childhood experiences. So what is trauma? So this is one definition, an emotional, psychological, or physical response to a distressing or disturbing event, overwhelming one's ability to cope. We know that this can really affect people emotionally, behaviorally, and it causes structural changes to the brain. And some of those in different types of trauma affect the brain in different ways. And at the end of this, I'm going to put Javier on the spot and just ask him to sort of give us some neuroscience buzzwords or words of wisdom about trauma. Sorry, Javier. But yeah, we have acute trauma, chronic trauma, complex, and vicarious trauma. And so we want to be aware which category we're operating in. And for my clients, I would say mostly they've experienced all of these. Okay. There's also intergenerational trauma. So we think about people who, if say parents who they had domestic violence and they have a kid, or say the parents grew up with child sexual abuse or physical abuse, then they have children. Their children's genes are going to be different because of the experience of trauma that they had. So it's not only that they might parent differently or they might have responses that are that really are reflective of the trauma, but their genetic expression, their epigenetic expression will be different. And so I think that's something that we are becoming more and more aware of, especially in the field of epigenetics. And this is something that we'll be detailing in the library. There's also there's a number of common symptoms of trauma. So for example, there's a federal court judge, Judge Salas, who comes to speak at our Federal Judicial Center conference at Harvard Law School. And she talks about how, prior to really becoming more aware of trauma, she would have very dysregulated responses to, defendants who would come before her who would, yell or be upset or be annoyed with her, and how, through her own journey and experiencing her own trauma, she was able to appreciate that some of these were symptoms of trauma and, for the defendants, for her, and she was able to really respond in a much more regulated and empathic way. But again, I want to say that the behaviors that most people engage in who've experienced trauma at some point serve them. So part of it is figuring that piece out so we can take out the moralization that is very endemic in the court system, at least in the United States. So we're in the library, we'll be in the new module, which will be released later this year. We'll talk about how toxic stress affects the brain. So here are another details of stress and the brain regions that are most affected by trauma. And I don't know, Javier, if you want to just talk a little bit, I know this isn't specifically your area, but maybe about how the brain is affected from toxic stress. And feel free to use these notes as well.
Sure, and I may do that, Stephanie, because they are great notes. This is exactly where sort of my mind drifted when you started talking about trauma. But as you might imagine, someone who's in an environment that presents a lot of threats to them, and threats can come in many forms, Um, often for human beings, who are at the top of the food chain, the threat is another human being, right? And so when a brain encounters a threat, it engages, it starts our fight or flight programming. You may have heard that kind of terminology before, but that gets your heart rate elevated. That gets your breathing to increase. Your digestive functions are inhibited. All these important biological functions are sort of kicked off by your brain recognizing these threats and saying, okay, we need to sort of take all the energy we have in our body and focus on getting away and surviving in this particular instance. Our brains are actually pretty good at doing that, but they're not designed to do that all the time. Doing that all the time, sort of taking energy from uh, stable emotional processes, stable cognitive processes, and putting them into our fight or flight responses is not great for the body. And so over time, you have a brain that's reinforced in engaging in this kind of thinking and identifying threats very quickly, right? And responding to those threats very quickly, and getting the body really activated to respond to threats. And that's mostly see that a lot of that sort of behavior is triggered by what we call lower parts of the brain. That doesn't mean that they're less important in function. They're literally found in lower aspects of your brain. And one of those regions is called the amygdala. The amygdala is very, very important for fear responding, not just in humans, but in many other animals. We found this. And over time, if you engage in a lot of this fear responding, your amygdala does get bigger. We find that people who live in certain environments, certain places, certain geographies where they might be exposed to crime or threats, tend to have larger amygdalas. So their system is a little bit more primed to respond to things that might be perceived as threats, whether they ultimately end up being threats or not. Likewise, there's a system that's sort of dedicated to tamping down those responses. And that system stems from the prefrontal cortex. It's sort of upper brain. And that upper brain has a lot of connections with lower brain to tell it, hey, I recognize that this is a threat, but it's just a picture of a gun and not an actual gun. Okay, so we don't need to engage in our usual gun mechanisms of behavior, gun responses. That part of the brain is actually in those same people who live in sort of high stress environments, that part of the brain is actually very inactive compared to what it would normally be like. So you have sort of these two systems that normally work in tandem. One becomes overpowered in response to high chronic levels of stress. The other one becomes underpowered. That acts as the brakes of the car. So the accelerator is very good at going, but the brakes are not very good at stopping the system. And overall, over time, you have, with your brain responding to so much trauma, so many stress situations, you can have other consequences besides just those two systems. You can have neuroinflammation. A lot of the support cells in your brain that keep your brain healthy, the metabolism going, actually stop functioning as well. And you have neuroinflammation, which can cause all sorts of other problems. Including in regions like the hippocampus, which is important for making memories. So one of the systems that is really jeopardized by chronic stress states is just general systems of learning and cognition and memory. Okay, if you're designed to sort of look out for stressors and respond to them, that takes away less resources from learning things like in a classroom, right? So yeah, I think this is a pretty good overview. I'm happy to talk more after the presentation about some of these things, but I think
Thank you, Javier.
it's a
Yeah,
great
thank
starting
you.
point.
So helpful. Yeah, it's good to hear from an actual neuroscientist. I just pretend I'm a neuroscientist. And what's interesting from a legal standpoint is a lot of our laws and even rules of evidence are predicated on myths about how the brain works. And we'll talk about this a little bit more in the memory module, which I'll talk about in a second. But so, for example, the hippocampus is negatively impacted when you experience trauma. And so when you're experiencing a traumatic event, your memory constellation is much less strong. And so the memories that come from a traumatic incident are they tend to be less robust, especially if it's more chronic trauma. And we know from asylum law, for example, that in order to be granted asylum, one of the benchmarks is having a consistent narrative of the trauma that the person experienced. But if someone was sexually assaulted by, 7 different men, 7 different times, or 15 different times, and they're giving the narrative, then from a neuroscience perspective, it would make sense that they wouldn't have necessarily 100% consistent narrative because that's not how the brain works. But from a legal perspective, that's the expectation. So some of this module will be debunking, some of the science that I think some of our laws were predicated on. Okay, this is going to be a super quick lesson on the science of memory. And again, I think I said this at the top of the hour that, or the beginning, that a lot of our evidentiary rules are sort of don't really make sense when you really sort of understand the science of memory. And I think all of us are familiar with at this point with the challenges and sort of the myth of this like light bulb memory where flashbulb memory, where you're just understanding everything like it's a movie and you're remembering it like a movie. And when we think about eyewitness testimony, there's this big drama of, can you point to the person who did this to you in the courtroom? And the person points to them, and everyone's like, "Oh my gosh!" And this has to be 100% correct. But what we know from years and years of scientific studies, and from all the people who've been exonerated based on exculpatory evidence, is that this flashbulb memory is really a myth. And so there's a lot of challenges with, for example, eyewitness testimony, even though juries tend to really give a lot of weight to this type of testimony. In Massachusetts, at least, we have specific jury instructions about eyewitness testimony because there's so many problems with it. So in the law, we see memory as kind of like a video camera, and it's given a lot of deference, which is inconsistent with the science. We know that the formation, storage, and retrieval of memory can be really heavily influenced by outside factors and also things that are, just natural to the person, such as having an illness or brain injury or experiencing trauma. And we also know that when people testify and their testimony may feel accurate to them, but it's really filtered through distorted memory, that can lead to wrongful convictions. And so this is why this module, I think, is so important so that people can understand why eyewitness testimony can be problematic. Also, things like false confessions. So, we're working on a case in Texas where a woman was charged with the murder of her 2-year-old son and has been on death row for decades. The autopsy pretty clearly demonstrated that the child fell down the stairs. And only recently, this woman has been essentially, well, it's a complicated process in Texas, but her conviction was overturned, but she's still sitting on death row waiting for another court body in Texas to rule on what has to happen to her. But this was a case where she said she didn't kill her child 100 times, and then the police officer during the interrogation was, for example, playing with her hair. This woman was sexually abused by several people, and so that was obviously uncomfortable to her. And eventually, with a lot of other circumstances that were problematic, she confessed and then retract her confession. But it was enough to contribute to her capital punishment sentence. So being able to talk about why false confessions happen, and I really do think that just based on the science, almost anyone could be could in the right conditions falsely confess to something because of just the psychological pressures that are involved. And these also memories implicated a number of different brain structures. And so with the next module, we're going to talk about each of these brain structures and make them applicable to the legal sphere. And then I'm going to skip over this. Okay, and then there's a number of disorders of memory that occur in the legal system. And so I think part of this is we're going to be describing those disorders. And, even post-traumatic stress disorder affects memory. So, if a defendant is trying to take responsibility for a crime and doesn't get the facts right, that could be, for example, because they've had their memory influenced by some of the past trauma that they've experienced. So We have a number of articles that are going to be on the website that are grounded in trauma memory that can be used in legal advocacy. So this is an article on, for example, solitary confinement and the neuroscience of solitary confinement. This is a big issue being litigated, I think, in every state in the country, because we know that solitary confinement, creates brain damage. So being more aware of that, and being more aware of the neuroscience can help lawyers to advocate for clients. This is about trauma, effects of trauma on feedback processing, cognitive neuroscience, perspective on memory, and so forth. Yeah, the science of human memory versus the federal rules of evidence. I think this is fascinating. And then we also are going to have a number of cases, and I'm going to turn this over to Andrew to talk about some of these cases because the Center for Law-Abiding Behavior, at least one of them, we've had a role in.
Yeah, so we've emphasized a lot of the science we're trying to distill, but as part of making it actually actionable and, usable for a lawyer, we find that it's really important to also show example cases that either show the shortcomings of past efforts to bring in the science or really successful instances of bringing in that neuroscience to be a better advocate, or just to better align the, legal system with the science at hand. And so I'll just go through these three cases really quickly. I think this captures a key reason why understanding the actual relevant law is relevant to understanding what the science we talked about can actually do. Because in this case, we actually look at the role of claims of ineffective assistance of counsel. And so one area that we try to have cases around is cases that really describe exactly what the obligation of an attorney is to their client when it comes to understanding their history. And so, as the science becomes undeniable that PTSD contributes to the formation of memory, right? Or the lack of formation of memory, and that early childhood trauma, affects the way that people act later in life. It becomes all the more important for an attorney to actually bring that evidence into the picture, and understanding exactly what the legal obligation is important for then, having a case looked at again, or at least having that level of representation brought in the first place. And so, yeah, this is a case in a federal court that in which the Eighth Circuit found that the bar was not reached, yet it's still a very valuable learning experience. And we can go on to the next case. This is a case that, yeah, we definitely want to highlight. We were talking just now about the role of neuroscience in better aligning the legal system with how they treat in solitary confinement cases. And this is a case that actually got brought up to a court of appeals on the federal level, in which Center for Law-Abiding Behavior was able to submit an amicus brief detailing the neurological and neuroscientific harms of solitary confinement. And this is a really troubling case to get involved in. It was an individual who was serving a 10-year sentence. They went into prison with an existing substance use disorder. They tried to get into the prison's treatment program, medication assisted treatment program. They were rejected from that treatment program, and then shortly after were found having overdosed on an illicit pill that was laced with fentanyl. And in response to that discovery of the person being found with an overdose after not having the right treatment, the response by the prison was to put them in solitary confinement for 55 days. And so in this case, it was eventually appealed. And what the court found, based on neurological evidence, including the brief they actually cited in the ruling, they found that it actually was a violation of the Eighth Amendment against cruel and unusual punishment by continuing to keep this person in solitary confinement, despite very clear evidence that they were continuing to deteriorate in that state. And so it's a very strong example of just how important it is to actually make sure that a court has that neuroscientific evidence with them when making decisions. And then I'll quickly just go to one case about memory. So this is a case that went up to the Supreme Judicial Court of Massachusetts, in which very clearly the kind of availability of the latest science on eyewitness identification actually led the court to say, okay, we have to look at this a little bit differently and reconsider whether or not we treated the eyewitness testimony in alignment with the science. And as you can see, this is a 2024 case, so it's very much still an evolving area with the science that continues to come out. And so we're hoping to continue that trend to ensure that every court is best equipped to respond to eyewitness questions.
And Andrew, do you know in this case how much they weighed the science or how they got access to the science? Was it through amicus briefs? Was it through an expert in at the trial level? Or
I'm not sure about the experts at the trial level, but there were definitely amicus briefs involved. Um, and yeah, I mean, I think what's great about this sort of information that we're putting out there is that at every stage, right, this is stuff that's relevant to be considered, whether or not an expert gets involved. A defense attorney should be able to, include this information. Um, yeah, I can get back with more specifics on this case. I'm not sure
sounds good,
about the
not to put you
exact
on the
procedural
spot.
history. Yeah.
Yeah, and we have a huge database of amicus briefs. So, if people are in, say, the state of, we just did an amicus brief in Arkansas, they can, look and see what is being filed in other states. They don't have to reinvent the wheel. This saves busy public defenders or even prosecutors time. Okay, we're gonna skip over this video, but we have a bunch of videos on toxic stress. Okay, so lessons learned from the criminal legal field. So in the past 6 months, for example, the way that we've gotten the library out there, because it doesn't sort of help anyone if it just sits on the digital shelves and no one looks at it. We really want people who are, like I said, public defenders, people who are incarcerated, their families, prosecutors, judges to be looking at the library and getting up to speed on neuroscience. So, for example, in the last week, I presented week and a half to the Arizona court-appointed special advocates, the Ohio court-appointed special advocates. Yesterday, I'm trying to remember who I presented for. I can't remember. It's been so many presentations. And then next week, we're going to the state judges conference, and I'll talk about the NeuroLaw library. And we're just sort of often presenting, and we say yes to pretty much every presentation. This is Andrew in Washington, D.C. at the National Legal Aid and Defenders Association. This is us last week at the Graken Center Addictions Conference, where people were like very excited about the Neuro Library, which was really cool to see. Next Wednesday, we're going to the Equal Justice Conference in Charlotte, North Carolina. So we're really just trying to get the word out. The other thing I wanted to share is our Adovo course, which is something I'm extremely excited about. So, when we made the library, one of the reasons we put in this comprehension slider to go all the way down to the 5th grade is we wanted people with different learning levels to be able to access the library. And people in prison, some of them have doctorates, some of them, are at a 5th grade reading level. But we wanted everyone there and outside to be able to access the library. What we soon found is there were serious barriers to getting so-called whitelisted or getting access, getting facilities to give access to people who are incarcerated to be able to use the NeuroLaw library. So what we did is we modified the NeuroLaw library to platforms, learning management software that is available to people who are incarcerated. So this is in over 1,500 prison and jails, 80–90% of US correctional facilities. This is the Adovo platform. And what we did is we made a course, and we made a NeuroLaw course about neuroscience, substance use disorders, adolescent brain development, trauma, mental health, foundations in psychology, and we made it accessible to people who were incarcerated. Now, this was pretty cool. So over 20,000 people have started the 5-unit course, and over 75% of people who started the course have completed the first unit, and nearly 10,000 have completed all 5 units. I think we're over 10,000 at this point. So it's a really high number of people who are utilizing the course, and we just released, a few months ago. And the unit on the neuroscience of addiction has the highest completion rate, which is around 98%. And what's been awesome is seeing the reviews from people who are incarcerated about what the NeuroLaw course has meant to them. So this is a learner from Florida South Bay Correctional Facility. This course needs to be shared with the entire incarcerated population. This is another learner in Tennessee, Morgan County Complex, a true eye-opener, and was helpful in learning things from my past that has unknowingly affected me. So part of this is just helping people to empower themselves by understanding NeuroLaw and understanding how to use neuroscience and leverage that neuroscience in their legal cases. We've also been in the Providence Journal, And we have we're in talks with Mother Jones and working on trying to make inroads with the New York Times and the New Yorker to try and get more press about this so that people will know who we are and how to use the library. We also have a very cool initiative with the Jailhouse Lawyers Initiative. Andrew, do you want to talk about this briefly?
Sure, yeah. It speaks to the point we were making earlier about, trying to think about how we can make sure the content of our library is really utilized and actionable to, everyone who could benefit from it. And we were very fortunate to be able to pair up with this group housed at NYU Law called Jailhouse Lawyers Initiative. They have a network of 1,200 jailhouse lawyers who are people who are currently incarcerated and basically act as in-house legal counsel to other people who are incarcerated. They uh, very rarely had formal legal training outside of a prison or jail, but in the course of being incarcerated, have become the kind of local experts at helping people out with their cases. And so a lot of these individuals who they're helping out often were sentenced when they were either under 18 or in this category of emerging adults between 18 and 25. And this toolkit basically got out all of the information that's housed in our neurolaw library on juvenile and young adult brain development, as well as the relevant cases to ensure that these jailhouse lawyers have this at their fingertips really when helping out clients. And what's been pretty terrific is that we've also had significant outreach since then from jailhouse lawyers. And so just tomorrow, I'll be shipping out some further materials to an individual who's a jailhouse lawyer who has been in touch with us. Because, yeah, as Stephanie was saying, getting our website whitelisted in prisons and jails is a very difficult process across different states and probably an impossible prospect in some states. And so we're really continuing to think about how we can get this out there in whatever format that is. And so here we are, I'm in a room with the jailhouse lawyers team at NYU, literally shipping out over 1,000 packets and thinking about all the different mailing restrictions for each state and how mail is processed. But that's the kind of stuff you have to do to really, make sure this is utilized everywhere. And so, yeah, it's a big thing we're thinking through today.
Well said, Andrew. And yeah, we get a ton of mail. And so being able to respond to the mail from people who are in prison is really, I mean, it's something that we really, I think, appreciate and value doing. And it's also really complicated because every facility has really strict rules about mail. And so, for example, we have someone that we're talking to in Pennsylvania, and you would think you would just send the mail to the Pennsylvania Department of Corrections where he is, but instead the mail is actually sent to Florida. And so if we didn't know that, then we would have just sent him the mail and it'd be returned. So it's very complicated. And with this toolkit, we also included a free expert affidavit from Dr. Kristen Carson in Seattle, Washington. And so people were very interested in this affidavit. So she's also gotten a ton of mail that we respond to. And I think being able to get these affidavits out there so that people can file motions or they can include them in their appeals is really helpful. Yeah, and so we also write amicus briefs and we become very nimble at this. So for example, on April 1st, we got an email asking for an amicus brief for someone who was 18 and 43 days, so not eligible for the Miller v. Alabama protections. And I think we got the records 2 weeks later, and by April 22nd, we had filed an amicus brief. The filing deadline, I think, was April 25th. So we got it in, we had legal counsel, local counsel. So this is something else that we really value doing. Okay, so here are the things that we're still figuring out and would love, feedback on. Um, Especially when we present locally, we have a lot of people who would love to help and support our work. And one thing we're thinking about is how can we use volunteers? I think it can be tricky because training volunteers can take a long time, and then it takes us away from some of our impact work. So thinking through, like, is there a way that we could use volunteers? What other toolkits would be helpful for attorneys or people who are incarcerated who are looking for science-based advocacy? How can we better reach people who are incarcerated? At this point, we have, the relationship with jailhouse lawyers. We'll be doing another toolkit on the science of addiction, which we're really excited about. And then we're on the Adobo tablet, but we're still thinking about how we can be more helpful and how do we gain more nuanced, favorable coverage from the media. So for example, the Providence Journal story was called, the headline was Neuroscience Class Helps RI inmates understand and change harmful behavior. So this might be true, but I think also true is that people who end up in prison tend to have histories of horrific trauma. They tend to be affected by poverty and community violence. And so they don't just end up in prison usually because they are just irreparably, broken from birth or even psychopathic. Most of the clients that I work with would not meet criteria for psychopathy. But how do we get news coverage that sort of looks at this in a more complex way, which also appreciates the systemic factors that contribute to incarceration and mass incarceration? And how many articles is enough? So it takes us a long time to upload these articles because we have to create, I think, Andrew, is it 6 different versions? Is it 5 or 6 different versions of each article?
Yeah, I think it creates 5 additional reading levels. So yeah,
Yeah,
6.
so each of those reading levels we have to look at, someone with expertise in neuroscience, psychology has to look at to make sure that the AI generated summary is correct. So they often need to be modified. And then, especially for some reason, law review articles can take, it feels like days to upload because you have to change all the formatting. And all of our articles are open source. So, yeah, so that's something we're thinking about. And I think just any other suggestions would be so open to receiving about the NeuroLaw Library. We're a small team, but I think we're all really passionate and we're always willing to go in, present to people, just to get more attorneys and people who are incarcerated using the library. And like I said, it's a completely free resource. So it's really just about getting the word out. So if you want to sign up for our newsletter, there's a QR code here. And then my email address is on the left. And then I'd love to open this up for questions, comments, feedback from all of you.